So this afternoon, we have Faye Luppi from the Violence Intervention Partnership, which is a program out of Cumberland County. And she's going to be doing an overview introduction to risk assessment, which will be a companion and sort of a prerequisite to a training we're going to do next week that's specific to the ODARA risk assessment tool that we use here in Maine. And with that, I'll turn it over to Faye, and Faye, I'll let you introduce yourself. Thanks.
Okay, thanks, Kara. So I'm Faye Luppi. As Kara said, I coordinate the Violence Intervention Partnership, which is Cumberland County's CCR, Coordinated Community Response to Domestic Violence, and I've been doing that since the late 90s. But before that, a while before that, I was a prosecutor in Cumberland County. So I do have sometimes you'll see that prosecutor hat come on. I've also started using the ODARA and was trained as a trainer in 2007 and 2008, and also am trained in the danger assessment and have done a number of consulting work with other states trying to implement risk assessment, and worked with the developer of the ODARA as she was writing her second book that came out in December around our implementation process in Maine. So have some experience there. And I was just explaining it a few minutes ago that one of the reasons we're doing this piece first is that I do more as I do more and more work on ODARA and risk assessment. It has become evident that I think we need to understand the larger context when we're working with risk assessment. So that explains this introduction and some of the things we've learned in using risk assessment in Maine in the last 10 plus years. So just a quick, Amy, and did you say Cindy? Is that where? I know, Amy, you're in Penobscot, right?
Yes.
And Cindy?
Saginaw County, sorry.
Okay, so just to know where you're coming from is helpful as we're talking. And please ask questions if you have them, comments as we go along. I'm more than happy to talk with you. This is meant to be interactive and helpful. So I'm going to start. This is the lawyer part with a definition, and that is. So we were very fortunate when we were starting to develop the work around risk assessment and ODARA in Maine, and working with a researcher at Bates, and he sort of came up with this, and I found it to be useful. So we measure some characteristic of a person or a situation, and then we use that information to predict the likelihood of something, usually a negative event, that is going to happen in the future. And it's important because in the case of ODARA, for example, it is re-abuse that's measured by rearrest that we're predicting. But there are some other tools that I'm going to talk about where what's being predicted is lethality. And I'm going to talk a little bit about how those tools complement ODARA and the tools like ODARA that focus on the offender, whereas these lethality assessments focus more on the victim or on the survivor. So before I go to the next slide, I just wanted to ask you, assuming that you've been, you've heard about risk assessment or that you use it in your work, why do you think that we adopted it in Maine? Why do we use it? How do you use it? What are some of the ways that you use risk assessment in your work?
We use it for safety planning.
Absolutely. That's one of the key things. I think the other thing that it's also done in this work around risk assessment, it's helped broaden the conversation with all the stakeholders about risk assessment and about safety planning and the importance of it, and trying to identify the risks and then safety plan around those risks. But that's been one of the great parts about teaching ODARA classes around the state, is to have those conversations. Other thoughts about how we use it or why we use it?
You almost have a sixth sense about the persons or offenders that you're going to see back again. They might have even made threats from prison or in court that this isn't over and I'm going to, you know, I know how to get you. And the intimidation keeps going, even though they may be out of the picture for a while, and they're going to get out of prison eventually. The ultimate.
And I think what you just pointed out is a really important use of some of these tools, is that it gives us the vocabulary to say, yes, this is a risk, and here's the research that supports it. Whereas before, I think we came into the courtroom or we came into meetings with, this is a really bad case. I have this feeling, as you were talking about, but it gives us something, to a foundation or a context to put that information that we know from our experience, but that it's not really admissible in court. You know, it gives you a way, and it gives our judges a way to rely on something that's admissible and scientific that we can use. It's also a way to communicate with people from other jurisdictions. One of my favorite stories about when we adopted risk assessment was one of the people was a bail commissioner who was first trained early on when we were doing this. And she said that what it helped her do was that when she got that phone call from the jail at 2 o'clock in the morning about a domestic violence case, and they were able to tell her the ODARA score, which was maybe an 8 or a 10, she said it really woke her up. She said she realized just in that one piece of information that she was dealing with a case that had a lot of danger and that she needed to ask a lot more questions. So it was, you know, kind of that vocabulary piece. So these are some of the things I think that we've mentioned: common language to communicate risk across disciplines, educating people about dynamics, and informing, as you said, Amy, assertive safety measures for victims and also containment measures for defendants. Components of high-risk response teams. Do either one of you have high-risk response teams in your jurisdictions? I know you do in Penobscot.
Yes, we do.
Saginaw, not. So this is one of the pieces around risk assessment, is once you identify the risk, then what do you do with that information? And one of the things that we've done in various places in Maine is to try and develop these high-risk response teams where people from different disciplines, usually within the criminal justice system, come together and talk about the very most high-risk cases that are identified through risk assessment. Another is to provide that lens through which victims can view their situations, and we've heard from advocates from various agencies and from various offices that sometimes if they sit down with a risk assessment with an ODARA, you know, they would say, wow, you know, I had no idea, you know, because sometimes they don't know about some of the things that are involved in the risk assessment. And the final thing is kind of the efficient use of scarce resources. It's like, how do you figure out who gets, if you have access to them, who gets the alarm system, who gets the VARDA, who do we recommend for electronic monitoring? We're fortunate in Cumberland County we've developed an electronic monitoring project where higher, not the highest, because they shouldn't be in the community anyway, they wear an electronic monitor, and there are zones they can't get within a certain distance of where the victim lives and so forth. So how do you use these? You know, if you only have a few of these, how do you allocate those scarce resources? So that's what I like to start with when we're talking about it. And here are some of the sort of the general principles when we developed risk assessment in Maine, and that in working with other jurisdictions that I've come to think about is, you know, the first thing is to ensure that that what we're doing doesn't re-victimize the victim or cause unintended consequences. And one of the best examples of that is the second bullet, which is who's going to have access to this information once it's gathered. I mean, you gather a lot of sensitive information in your work, and you have procedures to keep it confidential. But with these risk assessment tools, no matter which one you're using, You want to make sure that it doesn't get used, for example, down the line in a family law matter, or another kind of a court proceeding gets used to the detriment of the victim. So how do we design these so that we can not re-victimize the victim? And also, how is the victim going to be informed about how this information is going to be used? So that's part of something for you all, for you to think about in your work. If you get that information, and if you explain to the victim about a high risk response team, who's going to be at the table, and you want to be able to talk to the other people at the table and bring the victim's concerns to that group. And that's all part of this. And also not to use risk assessments, for example, in determining eligibility for victim services, or even, we've been having some careful conversations about the potential use of risk assessment in protection order matters, for example, where you don't want to say, well, it was a low score, so she doesn't get a protection order. Because we know that the risk assessment tools are only as good as the information you get to put in them. And we'll talk more about this in a few minutes, about what is the information in some of these tools, and when is it reliable and when is it maybe not reliable. And that you have these tools that focus on the likelihood of re-offense, like the ODARA, as opposed to lethality. And there are different factors sometimes. So sometimes you need to look at both. So, and not use one of them to say, well, she shouldn't get this X or Y because the score is low. And I was explaining to Kara that I was just talking to some folks in Kansas who were talking about implementing risk assessment at lunchtime. And one of the things we were talking about was training in the use of the tools. And that's part of why Kara asked me to do this, to kind of have this conversation with you around training, because some of the tools are a lot more accurate if you've had some training. And that's why we make sure that our law enforcement have been trained in how to score the ODARA. And that if you're going to be using the danger assessment, that you have some training in that, because they're more accurate. And we also spend a lot of time, I spend a lot of time at the academy when I'm training cadets, saying it should never be used to make arrest decisions, because these risk assessment tools predict the likelihood of another assault or the likelihood of lethality. They don't help the officers decide whether somebody should be arrested or not. They don't help them with, has domestic violence occurred? Did this person assault another person? They don't have anything to do with that. And sometimes people don't understand that. And I think it's also really important. We're really careful in Maine, and that's my prosecutor hat coming out again, is sticking to protocols and understanding that the tools should be used in the settings for which they were designed. So the ODARA was specifically designed for use by law enforcement in the criminal justice system, and to help people setting bail and prosecutors and judges and probation officers make decisions about the cases they're working with. And then also what's going to happen differently because the decision maker has that information. And that's why some of the jurisdictions in Maine have developed, and others are beginning to develop, these high-risk teams as a way to, once you get that information, what are you going to do with it? I did some training out for a native tribal group on the West Coast a while back. And at one point when I was doing all this training around ODARA, the chief was sitting in the back of the room, and he raised his hand and he said, well, I see all this that you've got there, but what I want to know is, will this make my people safer? And I said, wow, I mean, that really encapsulates, that says it all, doesn't it? It's why we're doing the work we do. And I said, well, I think yes, I said yes, because I think it's always helpful to have more information and to allow victims to have more information on which to base their decisions. But I also think it really depends on how you use that information. So, which is why I've been an advocate of the high-risk teams, and, talking to groups about, thinking about before they adopt these tools, how they're going to use that information once they get it. So those are some of the basic principles around risk assessment. And this is just a diagram about what I was talking about. And when I say risk assessment, I'm talking about sort of the tool we use in Maine that looks at how likely the offender is to reoffend. And then there's the lethality tools that look at, how likely is this victim to be killed in this relationship in the future. And that's kind of what the danger assessment focuses on. And then we have sort of our safety planning pieces that you were talking about that kind of like takes these identified risks and then makes them into a safety plan. So these are the tools that we use in Maine. So I just wanted to give you a brief overview of these. As I said, we're going to go into much more detail about ODARA next week, but I wanted to look at the differences between the two so that you could see how well they complement each other and how they're both parts of the safety planning and decision-making that we use. So the ODARA focuses largely on the offender and has a few items. So there are 13 items in the ODARA that focus largely on the offender. And it measures recidivism, the likelihood that this person is going to reassault. It was used initially in Maine in the Maine criminal justice system, although it's not necessarily limited to that, with some precautions we'll look at in a minute. It is fairly incident specific in that it focuses on an assault and looking at what happened during that assault, how likely the person is to reassault in the future. It does include information from the larger context of the relationship, but it doesn't focus, it starts with an assault. And it takes about 5 to 10 minutes to administer, which is one of the reasons that we chose to adopt it in the beginning. The danger assessment is largely victim focused. It measures lethality, how much danger is this person in terms of what Jackie Campbell calls femicide, being killed by a partner or being seriously injured. It's largely used by advocates or healthcare providers. That's what it was developed for, because it takes about an hour to administer, and it really asks some more personal questions. And it looks at the larger context of the relationship. And we'll look in a minute at some of the components of it. But as you can see, there are actually some overlapping items, and I'll mention those as we go through. But they are different tools, and they focus on different things, and they're used for different purposes, but they're both really helpful. And they're also, at least in the way we are high-risk response team operates in Cumberland County, we try and look at both. We try and look at the ODARA score, and then we also look at some of the lethality factors that the advocates have been able to identify for us. Just want to give you a little sense of how how risk assessment was adopted in Maine, and then again, we'll go into a little more detail next week on this. But these statutes were actually adopted in 2012, and they went into effect in 2015, which gave us the time we needed to train all the people who needed to learn more about risk assessment. And that's the police, the law enforcement officers who are who are scoring the tool, but also all the other people who are making decisions based on the tool, like you and prosecutors and judges, kind of all went through training around what does it mean to say that somebody has an ODARA score of 10? What does that mean? What do we do with that? So this was the law. Law enforcement officers have to make a good faith effort to administer validated evidence-based, again, prosecutor hat, right? Validated evidence-based domestic violence risk assessment. And we didn't specify ODARA in the legislation. We said a tool recommended by the Maine Commission and approved by the Department of Public Safety, so that if a better tool comes up in the future, we don't necessarily have to change the legislation. And it also points out what we were valuing when we passed this, when the statute was passed. And law enforcement officers have to provide the results of the assessment to the bail commissioner and to the district attorney. And there's language in there that says if appropriate, because one of the things we're going to get into next week is not all domestic violence offenses have been studied for use with ODARA.
Right.
It basically focuses on assault. So things like domestic violence, criminal mischief, for example, if the old boyfriend, the ex-boyfriend comes and slices and the tires of the victim, or the new boyfriend, you don't use the ODARA on that. You don't use it for stalking. So that's why it says if appropriate. But that part of what we wanted to make sure happened was this information got provided to the people making the decisions in a timely enough manner so that it would be useful for that decision-making process.
And Faye, we find we have a lot of judges and bail commissioners that ask for ODARA scores in same-sex relationships, or, parent-child or
Right.
child-parent relationships where they're not scored, and they're very upset that they don't have a score.
Right.
But
Yeah.
they're not studied. So we understand that.
It's not part of the, and unfortunately, the training that I did for the judges was 6 years ago now. And there's a lot of new judges on the bench who haven't had that training. So they don't necessarily understand the limitations. Same thing happens at jails, because they want that information. So they know they're supposed to give it to the bail commissioners.
Right.
And they sometimes won't take somebody if they don't have the score. And we try and train the law enforcement and others to say that the ODARA has been studied for use in these situations. And we want to stick with that so that we know that we're using it according to the research, and it hasn't been what we say is validated for use in these situations that are outside that. And you're absolutely right. There are a lot of people who haven't had that training and don't understand it. But that's why it says if appropriate. So I'm going to just spend a couple minutes on some basics of ODARA, not super details, but just so that you know, and then we'll get into a lot more details next week. But ODARA is an actuarial tool, kind of like those tools that are used for health insurance and car insurance and all that predicts the likelihood of something happening in the future, that indicates a likelihood that a male or female offender, because it has been validated for use with female offenders, not everybody knows that, who has already committed an assault on a current or former heterosexual, intimate, or dating partner. So you're absolutely right, Amy. It has not been validated for use in same-sex relationships. The only tool out there that I'm aware of that has is Jackie Campbell's danger assessment for female partners. That's the only one I'm aware of. But so it has not yet validated, and I'm using same-sex, but basically it's non-binary. It hasn't been validated for non-binary relationships, and it has also not been tested with juveniles. So we don't recommend that it's used in any of those situations, and also not recommended for use in intergenerational mother, son, or siblings. We have this broad definition of domestic violence or domestic abuse in the statutes. And this is to be used in a much narrower set of those cases, as you pointed out. And it is also, as I said before, it does not determine whether one partner is abusing the other. It doesn't determine whether an arrest should be made. It doesn't take the place of predominant aggressor. It was not designed initially to predict lethality, but they went back and did some studies, and it was significantly related to outcomes. So the cases that later did include a homicide had very high ODARA scores. So there was some correlation there. So I'm going to shift gears a little bit here and talk about a little bit more about the danger assessment, which is the tool that focuses on lethality. It's developed by Jackie Campbell, and as I said, it has 20 yes or no weighted questions, and there's also a shorter version that's used in other states. But it was designed to be completed during a victim interview by an advocate or a healthcare professional. And And as I said, there's no validated version for male victims. And there is one that's actually really interesting that was developed for use with immigrants. And it was very interesting for me to look at the differences between the danger assessment for mainstream population and for immigrants, because very high up on the list of risk factors in the sort of the general tool is possession of firearms. And that doesn't even exist on the immigrant one. It's not an issue. If they're going to use a weapon, it's typically not a firearm. Family, also, like having children increases the risk in the danger assessment and the ODARA, but it lowers the risk in the immigrant version. So it's kind of interesting to look at some of the differences in those. Here's some of the items that are on the danger assessment, just to give you a sense. So I don't know if your advocates like, for example, in your high-risk team, if they talk about lethality factors, but here's some of the items that are on the danger assessment and that have kind of long been on lists of what they call lethality indicators, because a lot of it was taken from this research by Jackie Campbell. So threats of violence, the use of a firearm, homicide, suicide threats, whether an abuser is unemployed, is like long-term unemployed, whether an abuser is using drugs and alcohol. It asks about daily life, whether the abuser is like a super controlling or super jealous, spying, stalking, whether they have, whether there is a child in the relationship that is not the biological child of the abuser. And that's actually also an ODARA factor. It's interesting that that one crosses and is a factor in both. Assaults on during pregnancy, also an ODARA factor, so one of the ones that crosses over. We've heard a lot in Maine, you've probably had some training around strangulation and sexualized violence. Those are factors in the danger assessment. And it also inquires about victim suicide threats. So these are things, obviously, that when you look at these, that it's even more important to keep this information confidential. The ODARA has a lot more objective information that's also available that's not confidential, but some of these, as you might imagine, could be used to increase the risk of the victim down the road if they got out. But just so that you know what some of the items are, and then I'll give you a little bit of a chart about the sort of how it works, the differences, and this was some from Jackie's original research. So the column on the left of numbers is the column when there was actually femicide, as she calls it, when the victim was killed or when there was an attempt to kill the victim. The one on the right compares 3 years of data from victims of domestic violence, but victims who were not killed. So the difference, if the physical violence is increasing over time, very highly more likely to be killed, more of a lethality situation. If you look, 62% had that in their history versus 18%. The other one, and Jackie uses this choke the victim, although we use strangulation, is really, if you look at that, if there's a case where there was strangulation, 50% of those cases resulted, in homicide. Only 10% on the control side. Firearms present in the house, that's the big one. 64% versus 16%. And then partner beat the victim while pregnant, 36-7. And then this one, if you look at the bottom one, is also a factor that we've noticed in Maine, and I'll talk about that in a minute. The abuser threatened or tried to commit suicide. So that's an important factor as well. So this is some of the research behind the lethality assessment, and some of the factors that we look at. And then I'm going to kind of zero in on Maine. Some of you have probably seen the recent homicide review panel report that came out in April of 2021. And they talk about the 5 S's, which makes it easy to remember. When I'm doing training, I always can remember 4, and it's like, oh, what's number 5? But so these percentages next to them have to do with, the first percentage is that which occurred in the just the last 2 years. But if you look over time, the 20-year look back that they did, that's the second number, the 53%. So serial battering, if somebody had more than one victim, we know that that's a big risk factor. At least in Maine, we've seen that. The strangulation, 750% more likely to be killed if there is strangulation in their history. Suicidality, that's why I was pointing out, if the offender has threatened or attempted to commit suicide, those cases were the ones that resulted in homicide, in the victim being killed in Maine. Stalking and sexualized violence, sexual coercion, those are the 5. And also being mindful of other high-risk behaviors, assault during pregnancy, threats to use or actual use of weapons. So those are that's the information from the homicide review panel. So I just wanted to give you that kind of grounding in the 2 kinds of risk assessment that we use in Maine and how they fit in the bigger context. Before we talk a little bit about, so how are these risk assessment tools being used, or how might we use them? And this is just a graphic that I borrowed from somebody who gave me permission. But some of them, as you can see, are criminal justice system, prosecuting attorneys, jail, bail, probation, betters programs. Some states look at ODARA scores to determine which kind of betters program somebody goes to. They've got different levels of whether it's 24 weeks or 48 weeks, like we have. Those are the criminal justice ones. Some of the others are a little more, they're more into the civil system. And we've been talking about with people, as I mentioned, can they be used? I know that I've done some training for psychologists who do custody evaluations. And, is this useful information for them? And, as I said, we're going to be very careful about using them in protection orders, because we don't want to say because somebody has a low score that they don't need a protection order, but that the risk factors might be helpful in thinking about both bail conditions or protection order conditions. If you know that this person has a long history of violating court orders, for example, or if the person has a significant substance abuse issue, that could be used to craft some of the conditions. Is sort of how we use some of these things. And we also use them in Maine in high-risk response teams. And I know, Amy, you're familiar with those. And Cindy, you don't have that yet in your jurisdiction, but I think that it's a helpful way to use this information. It generally involves people getting together from different disciplines, the prosecutors, the advocates, probation, Maine pretrial, people from the jail, law enforcement. Those are the folks that participate around the table in ours. And we look at specific cases that have been referred because of their high risk, either the ODARA score or the high risk lethality factors. And we talk about those, and then each agency goes back and acts on those. We don't create a plan or anything in writing, but we talk about what each agency is going to do with this information. For example, the person from the jail says, well, I will let you all know when this person gets out. Probation, we will let you know, what's going to happen, when the person gets out of jail, or what the conditions are. Or the law enforcement officer said, well, I'm going to go and do extra drive-bys, or I'm going to check on this. And the prosecutor's office provides information. Our victim witness advocates in our prosecutor's office are very important components of this team. And they can convey information from the victim that the victim has given permission to them to share about what the victim wants and what their concerns are. And also they can tell the team some real practical stuff, which is when the next court date is, and what, what's likely, what are they thinking about in terms of probation conditions or time or whatever, so that the other people can go back and talk to the victims and explain that. So we have that, and they're it's an evidence-based team, because it's based on the Geiger Center in Massachusetts, and they've done a lot of research that supports how these are effective in reducing homicides, reducing mortality. As I said, they're based on research, it's multidisciplinary, it's based on partners sharing information and resources and tools to manage high-risk cases. And I have to say they've been really helpful. I mean, we've had a CCR for over 20 years in Cumberland County. And I have to say that when we started meeting in this team, I was astonished at what information wasn't being shared. Everybody had good relationships, they talked to each other often, but we just didn't have this forum to share this kind of information about high-risk cases. So I'm going to spend a few minutes, take a look at the time here, a few minutes on just talking about maybe some broader concerns about risk assessment and how we use this information when we get it. One of the issues is risk isn't always static. It changes over time, and it can change. One of the things with the ODARA is, because it's incident-based, if you have an ODARA score this year that's based on a relationship with someone who has, and they have several children together, and then they break up, go their separate ways, and a couple of years down the line, the offender gets involved with another victim, and there's another assault. The scores might be different based on various things. The scores may change. The scores may change, and we're going to talk about this in a minute, sort of due to life circumstances too. There's also, you probably have heard about some of the concerns around the racial bias of the criminal justice system. And some of these risk assessment tools, including the ODARA, use criminal history in the risk assessment tools. And is there some kind of bias? And I'll talk about that in a minute. And as I said, there can be some life risks that just aren't part of this assessment, that sometimes need to be looked at in the larger picture. So this is information about sort of our current focus on sort of diversity and equity and criminal justice reform and so on. And so one of the research tools that I've used over time in looking at risk assessment, the person identified, so these instruments may have excluded the experience of different ethnic or minority groups, leading to bias that affects the effectiveness within these groups. So that means, like, for example, if you're talking about, well, I'll back up here. The ODARA was specifically tested in large, very diverse groups in Canada, in Toronto and other big cities where there's a wide variety. So they were included. And as I said, the danger assessment does have a separate tool for immigrants. And the developer of the ODARA, Zoe Hilton, this is when I asked her this question, and this comes from her book, that risk assessment tools, they might not be able to overcome systemic biases, like we know that there's sometimes a disproportionate number of minorities in criminal justice systems, but tools like the ODARA that are actuarial are one of the best ways to protect against bias in decision making. So bias that's based on the color of their skin or their race, that is a more subjective measure, whereas these tools have real objective, generally, criteria. So that's one way of looking at some of these issues, but understanding that they may not be as accurate in groups where they haven't been studied. And I think in particular about some of our new Mainers who are refugees or asylees from Africa. And this particular slide is based on that. woman was a victim of homicide by her partner in Lewiston. And some of these quotes come from people who were working with the Immigrant Refugee Center of Maine. One older woman from one of our New Mainer communities told Fatuma Hussein, she put her hand on her arm and said, "Young lady, domestic violence never happens in our community." So this kind of, just not recognizing it as something that happens for a variety of reasons. And we had systems in our countries that worked for us, and maybe some of those systems aren't available here in this country, like extended family. And I think the other thing is we don't know, particularly in using the ODARA that relies on criminal history, we don't know what the criminal history is of people who have recently moved to Maine, particularly if they came from countries where the government was dysfunctional or non-existent or involved in war, or they came from refugee camps. We have no idea what their criminal history was. We don't know about the unknown trauma history of the victims. Many of these communities rely on sort of the elder system that is somewhat controlling. So just, I put this under understanding their journey, is that just to use some caution in using these tools in some of our New Mainer communities, because they may not be as accurate. The other thing is language barriers. And this, I thought, was a really great illustration. It came from New York. It was a specific case about language barriers. And, we've gotten pretty good. I'm not great, but good about using language line and interpreters in the system. So in your offices or in the courts, there's generally interpreters in some way. But we forget sometimes that the information in the case comes from the scene. And how often do law enforcement officers at midnight on a Friday night actually call an interpreter to the scene to find out what happened? They have access, most of them, to language line, but again, that requires using either their own cell phone on speaker or two phones, or so this is a story about somebody who said she tried to tell police that her husband had pushed her, but instead of taking him to jail, they arrested her and carried her badly bruised to the precinct, and she was charged with a crime after pleading with officers for an interpreter. So it just, and I've heard people say, that criminal justice train starts at the scene, and sometimes it's hard to take it off the track if there's inaccurate information at the beginning. And we're relying on some of that information in our risk assessment tools. And we've talked already about this, and this is particularly of issue in our New Mainer communities. Some of the risks of sharing information are even greater. There's often a lack of confidentiality in some of these small communities. They may be facing immigration or deportation issues as a result of a conviction on a domestic violence charge. Victims who come forward often face isolation and stigma. And we even had in the case of the woman whose picture was on the slide, her family was threatened in her country of origin in Angola, because there was a prosecution against the perpetrator, the person who drove the car that ran her over. Her family was threatened to the extent that the organizations here in Maine came together and actually succeeded in getting the family to Maine, where they could be safer than they were in her country of origin because of information that got out. So judging the time, I think I won't sort of ask you to come up with these and just put them up here. But these are some of the other things to think about in terms of, yes, we have these really good tools that we can use, but these are some life-generated risks and some systems-generated risks that are the survivors that you work with have to contend with. Right now, especially, as you know, housing is a huge issue, and sometimes they can't leave a dangerous relationship because there's nowhere to go and there's nobody to help take care of the kids. who are maybe home from school because of COVID, language barriers, disabilities, limited job opportunities, and then some of the risks that can be generated within our systems. You've probably heard of cases where well-meaning child protective officers have told victims, you have to go down to the courthouse and get a protection order. And they get to the courthouse and they try and get an order, and they don't know why they've been sent, and they don't know how to do it. So there are some of these other types of risks that when we're looking at the bigger picture, we think about some of these things.
And I know you're short on time, but I just wanted to add, we had a Hispanic woman and all she spoke was Spanish. And we went with her to the courthouse to pick up the paperwork for a PFA. They have it in Spanish, but she has to fill it out in English.
That's right.
And it was enormously difficult.
That's right.
And then the judge has to read it in English,
right,
and try to relate to her, you know, what their interpretation is.
Exactly.
I don't know.
It's really hard. And I just was in a meeting last week with some people from the court system, and they were explaining that. They were talking about that. They do have the forms. They also have the guidebooks that are
Right.
translated into various languages. I think they're up to like 8 or 9 languages now, which is great. But you're absolutely right. It's basically for informational purposes only, and they need to fill it out in English, and the judge has to be able to read it in English, and then whatever order is finally issued is issued in English, and then they have to rely on interpreters to convey that information to both the survivor and the offender. So which are definitely challenges. And I know they are, I think actually Zoom, in talking to the person who is the responsible person at in the judicial branch for arranging for interpreters, they've actually been able to get more interpreters for languages that are very hard to find interpreters for by doing it via Zoom. And so they don't have to fly in, particularly if there's an interpreter needed for the victim, an interpreter needed for the offender, you know, so there's a couple of interpreters that are needed. And so it is, and there are some languages that are very hard to find, particularly when there's smaller communities. I mean, we had a case once where Through These Doors was using a language line based in California. It was the Pacific interpreters, and the voice of the interpreter came up, and the victim just was terrified, because it was actually somebody from Maine who was working as a contractor for this language line, and it was somebody she knew who was either related to or a friend of her abuser. So even with language line, we can't always be sure that there's not those issues that exist.
Yeah.
So but you're right. I mean, it is difficult to go through this, and we really only just have a couple more slides, so I'm happy to answer questions. And I've talked about this, about being aware of potential unintended consequences, re-victimizing the victim. What are we going to use the information for? And finally, the bottom one, risk assessments don't help us enter into the world of the victim's lived experience and why the victim is making the decisions that are being made. But what they can do, and we can mediate those consequences by understanding potentially the increased risks and danger to victims of being reported and involved with outside agencies, and understanding that some of these interventions might have different impacts on marginalized communities. But what they can't do also is guarantee victim safety. They can't substitute for best practices, and they can't account for risks posed by the intervention. But what they can do is that they can help improve communication of risk across disciplines, help us to allocate resources, enhance victim safety. And I'm going to add one more. They can give judges and other people a bigger picture and more context about what the officers observed at the scene. Before, we didn't have any, the people making decisions didn't have any information about children, substance use, history, criminal history, until we instituted this risk assessment process. The bail commissioners did not get access to criminal records. They didn't have that information before they made the decisions on bail. And so now they get that information, and they get this information to help them make more informed decisions. They get more context about what happened. They get information about risks so they can make more informed decisions. And that's how we are strengthening our coordinated response to domestic violence. So that's the end of this general presentation, and I'm happy to answer or have any questions or observations or thoughts before we start next week into a deep dive into ODARA.
This is amazing, Faye. Thank you so much. I feel like you really did a great job covering a lot in a short period of time. Yeah.
Thank you. Any questions or comments? Well, hopefully this has been helpful in terms of
Very
putting
helpful.
risk assessment into a bigger picture, rather than just doing that dive on specifically on ODARA, which I hope will be helpful next week too, to kind of look at the components of ODARA. But I think it's important to understand how we use that information, how we get that information, and how we use that information is what I tried to cover today, and then talk more about the specifics next week.
Faye, in Penobscot County, Penobscot and Piscataquis, we formed a group about a year ago where we reorganized the ODARA sheet.
Mhm.
And I'd like to send it to you. I don't know if you've ever seen it, just to see if you feel comfortable with our law enforcement officers using it.
I'm happy to do that. In fact, I think I've seen one of the Bangor ones.
That's the one that I'm referring to.
Yeah, but I don't know if I'm thinking of the one before it was redone or your new one, because I know that there are departments tend to do it in two different ways. They either incorporate it right into the sort of report and have the different items spread out in a way that seems to make sense in terms of their actual interviewing process, or sometimes some of them have it just the factors listed at the end. So there's two different ways, but I'm happy to look at what you send me and give you and here and give
Oh, great. That's what I was looking for.
Yep. And give you, whatever feedback in terms of what other departments do. I mean, but I can tell you that they do it two different ways. And the idea is also that it's not really the officers who explain the ODARA that they're doing it or what they're doing. That the way that it was designed, that was for generally victim advocates to sit down and talk with the victims about that at a later time, because the officers aren't trained in that process and in safety planning, and that's really the victim advocate's job. So that explains the reports and how the different departments have chosen to do it in different ways. But I'm happy to take a look at it.
Okay.
We actually did a reassessment in Cumberland County 2 or 3 years ago as well. And we used to have the diagrams with the, injury sort of, somebody was like with a little X or a circle or whatever. And our prosecutors said, you know what? We don't need that. We don't want that. We're going to get if there's been injuries, we're going to get the medical reports. That diagram takes up a lot of space on the report and we don't want it. We want other things. So it's interesting to have that conversation about how we can create useful reports. And we used to have a lot of check boxes. We thought, oh, that's easier. And the prosecutors again, and law enforcement said, you know what? We'd rather not use so many check boxes. We'd rather have a couple of lines where we can put in some information instead. So it was a very interesting conversation as part of our CCR. So I'm happy to take a look at it and just tell you what my experience has been with different departments.
Great.